Anyway, good morning, all. We have a judgment to deliver right away. Just a moment. Please, if your phone is on, just mute it. Stella, mute your microphone.
You can mute it. Oh, okay.
Judgment. Or rather, call the case first. Call the case first. Because I believe it's not been adopted yet.
Today, Monday, the 29th of November 2021, before His Lordship,
Microphone.
suit number MIC/OW/42/2019 between Mr. Hannah Esha and Remas Mandela. Claimant is present, my lord. Claimant is absent.
Please, my lord. I am. My lord, the change is
Okay, you're not continue.
Any changes?
Excuse me. Yes, defendant.
Evidence to be entitled to this claim.
Yes.
And we are urging my lord that seek to adopt this as our final
Yes.
argument in this case, and therefore urge my lord to discountenance the claim and dismiss the claimant's claim in its entirety. May it please my lord.
Yes. Yes. Yes.
All the relief. Source. In the said place.
Yes.
The claimant having proved all his claims.
Yes.
There is no challenge or anything for providing of those apartments and the place. So what you are not to grant the release.
Do you have any reply on points of law? No reply. All right. Well, like I said on the last adjourned date, I'll prepare the judgment before you come to court for adoption today. And by the grace of God, the judgment is ready. So I'll proceed to deliver it. Now, this claimant is a Syrian expatriate employed by the defendant company in 2011 to work as a project manager until 2019, when he voluntarily resigned from the employment. The reason for resigning his employment is that he was allegedly owed salaries from May 2014 to April 2019, coupled with other entitlements by the defendant company. Despite frantic efforts to persuade the defendant company to pay his outstanding salaries for those years, the defendant accordingly refused to do so. Hence, the claimant approached this court for redress. Now, the claimant originally filed his writ of complaint and accompanying processes on 4th July 2019, but subsequently amended same on the 16th of March 2020. By the said amended writ of complaint, he seeks the following reliefs. 1, an order of court directing the defendant to pay the claimant the sum of $210,000 being the unpaid salaries for 60 months from the month of May 2014 to the month of April 2019. 2, an order of court directing the defendant to pay the claimant the sum of $17,500 being the annual leave of the claimant for 2014, 2015, 2016, 2017, and 2018. 3, an order of court directing the defendant to pay the claimant the sum of $21,000 being the gratuity of the claimant for 2011, 2012, 2013, 2014, 2015, 2016, 2017, and 2018, calculated at 75% of $3,500 being the monthly salary of the claimant, which is equal to $2,625. 4, an order of court directing the defendant to pay the claimant 30% interest in all the judgment sums stating from the first day judgment is delivered until the judgment sums are paid. And 5thly, general damages of $35,000. I observe that the last relief, which is relief number 5, is only included in the claimant's statement of facts and not on the writ itself. The defendant filed and served the memorandum of appearance in this suit on the 5th of March 2020, then subsequently filed its statement of defense and accompanying processes on the 13th of March 2020, obviously out of time, which were all regularized on the 16th of March 2020 with the leave of this court. Same statement of defense was subsequently amended on the 20th of March 2021. Meanwhile, the claimant had opened his case on the 5th of March 2020, relying on his written deposition in open court as CW1 and that of CW2, one scholar, I'll check. They tendered 13 documents in all, exhibits C1 to C13. C1 was cross-examined by the Defendant's Counsel on both the 13th of July 2020 and the 17th of July 2020, whereupon CW2 took the stand to testify, and she too was cross-examined by the Defendant's Counsel. Thereafter, the claimant closed his case on the 17th of July 2018. I beg your pardon, 17th of July 2020. Now, the defendant eventually opened its case on the 27th of October 2020 by calling in the testimony of a sole witness, Wanchukuma E. Amanze, who relied on his written deposition of the 20th of March 2020 and tendered 4 documents, exhibits D1, D2, and ID1 and ID2, respectively. Now, interestingly, since 27th of October 2020, the defendant repeatedly failed to call in its second witness to testify, whereupon this court foreclosed it from bringing in another witness on the 5th of October 2021, thus forcibly closing the case for the defendant. It is, however, worth noting in this judgment that in the course of trial, on the 27th of October 2020, to be precise, the Defendant's Counsel announced to the court that the defendant admits owing the claimant the sum of $84,500 as its overall liability for the debts owed him, representing his unpaid salaries and allowance, and not the various amounts claimed by the claimant in this case. This court accordingly entered judgment on the said admission pursuant to Order 34, Rule 4 of this court's Rules 2017, and ordered the defendant to pay the claimant the said sum admitted on or before the next adjourned date, which was to be the 13th of November 2020. On the said 13 November 2020, however, the defendant failed to redeem its promise to pay the claimant and instead sought for an adjournment to produce an interpreter knowledgeable in Arabic for the purpose of translating a document, which was accordingly vital for their defense. The court thus awarded the cost of 50,000 naira against the defendant and again adjourned the matter to the 17th of February 2021. On that 17th February 2021, the claimant's counsel had announced to the court that his client had been kidnapped by unknown persons on the 15th of March of February 2021. And so the defendant was again ordered to deposit the check for the sum admitted by it to the registrar of this court for the claimant, and again adjourned the matter to 25th February 2021. Now, since 25th February 2021, the matter did not come up for hearing due to the intervening 2021 Easter vacation, the Jusun strike, which followed immediately from April to June 15th, and the unfortunate and various insecurities and crises that surreptitiously marred Imo State, thus necessitating the court to be on a compulsory hiatus and only partially attending to matters virtually from Abuja on the direction of the Honorable President of this court. On the 5th of October 2021, when this court eventually resumed from the third quarter vacation, the said sum of $84,500 was still unpaid to the claimant, and so this court ordered the parties to file their final addresses, since by that stage, both parties had already concluded and closed their respective cases anyway. Both counsels surprisingly filed their final written submissions and arguments on the same date, which is the 11th of November 2021. On the 29th of November 2021, that is today, the parties' counsel adopted their respective arguments and submissions. in a proceeding conducted virtually, whereupon this court immediately pronounced this judgment. As read from the pleadings, this claimant is an expatriate employed by the defendant in 2011 as a project manager, and he had accordingly worked in that position until the 24th of April, 2019, when he voluntarily resigned from the said employment. The defendant is a company registered in Nigeria with its head office at the NUT building, Teachers House, plot 1/9, Port Harcourt Road, Owerri, Imo State. According to the claimant, the defendant owes him salaries for the months of May 2014 to April 2019, a total of 60 months, which summed up to $210,000, supposedly at $3,500 per month. The claimant avers that the defendant company equally owes the sum of $17,500, being the total sum of his unpaid annual leave allowances from the year 2014 to 2018. According to the claimant, the defendant owes him another sum of $21,000, being the sum due to him as gratuity. The claimant supposedly made demands in writing orally to the defendants for the said unpaid salaries. Letter of demand dated the 10th of August 2016 was pleaded, as well as documents allegedly acknowledging the claimant's outstanding salaries by the defendant company dated the 2nd of December 2014 and the 7th of November 2016. The claimant's solicitors, to wit, N.J. Ubani and Co., allegedly wrote a separate letter of demand of unpaid salaries and annual leave to the defendant company on the 10th of May 2019. It is also the claimant's claim that the defendant ought to increase his salary every 2 years intervals, that is biennially, but the defendant failed or neglected to so do. Accordingly, the defendant only made the last salary increment on the 22nd of February 2019, when his salary was increased to $3,500, and this remained so until the claimant's resignation on the 24th of April 2019. The claimant pleaded a letter dated the 22nd of February 2013 as the evidence showing the last salary increment by the defendant company. The claimant's letter of resignation dated the 24th of April 2019 is also pleaded. Now, the claimant avers that his annual leave allowance is the sum of $3,500. He said that he made several efforts in ensuring that the defendant paid him his outstanding salaries, all to no avail. These include the interventions by the Controller, Nigerian Immigration Service, Imo State Command, Owerri, after which the defendant company invited the claimant to its office on several occasions. That is the 24th of May 2019, the 31st of May 2019, and the 5th of June 2019 for the purpose of paying him. But the outstanding salaries were never paid by the defendant company to date. According to the claimant again, he accordingly wrote a letter of reminder dated the 13th of June 2019 to the Controller, Nigerian Immigration Service, Imo State Command, Owerri, about the refusal of the defendant to pay him. Claimant further avers that save for payment for project interest made by the defendant in Naira, he had always been paid in US dollars by the defendant company. Claimant pleaded a project interest account statement from 2012 to 2014 in support of these averments. The claimant averred in conclusion that the defendant did not pay him his outstanding salaries, but only wrote a letter of no objection, that is admission or no contest of his claims to him, dated the 23rd of May 2019. In all, the claimant tendered these 13 documents in evidence in this suit. They are as follows. 1, letter of demand dated the 10th of August 2016, Exhibit C1, document of acknowledgements dated the 7th of November 2016, Exhibit C2, Letter of salary increment dated the 22nd of February 2013, Exhibit C3. Letter of resignation dated the 24th of April 2019, Exhibit C4. Letter of demand dated the 10th of May 2019, Exhibit C5. Letter of 13th June 2019, Exhibit C6. Letter of no objection dated the 23rd of May 2019, Exhibit C7. Debt acknowledgement document, Exhibit C8. Evidence of contracts supervised by the claimant, Exhibit C9. Evidence of impressed account, Exhibit C10. Staff ID card, Exhibit C11. Return flight ticket, Exhibit C12. And access bank statement of accounts, Exhibit C13. Now, the defendant, in its defense, alleged inter alia that the claimant was engaged by the defendant on contract basis and was duly paid and properly treated by the defendant. The defendant attributed its inability to pay the claimant for those material periods in question in this suit to economic downturn being experienced by the defendant company, including debts owed it by other companies and governments. The defendant avers that it is willing to pay the claimant, but that the claimant inflated the debts owed him far and above what it actually should be. The defendant avers further that it will only pay the sum admitted by
I will tell you your
Yes,
I will tell your email.
Amen.